Welcome to the Property Management Law Solutions Podcast. Your host, Attorney Tim Baldwin, will guide you in all things property management, law, markets, politics, and commentary. Your property is his priority. Here's your host, Attorney Tim Baldwin.
Welcome to the Property Management Law Solutions Podcast, everybody. I am your host, Attorney Tim Baldwin, and today we have Attorney John Mays with us. He's going to be sharing his insight, and I've had other attorneys on the show before, but this one's unique and special because John actually represents tenants. Okay, so it's going to be an interesting conversation with John. And so, John, first of all, welcome to the show.
Tim, thank you so much for having me. It's an honor. I've listened to many of your episodes, and I love what you're doing. I love listening to those podcasts, and I always learn something. So hopefully the folks at home can take something from this one too.
Absolutely. I know they will. So for everybody who's listening who may not know who John is, John, just introduce yourself. Tell folks a little bit about yourself. A little bit of background and kind of where you are today.
Sure, absolutely. I grew up in Panhandle, Florida, here in the Pensacola area. I've lived here pretty much my whole life, except for law school and my first job out of law school, which was down in Tampa. I graduated in 1998 from St. Thomas University, and that's in Miami, not the island, although I wish it was the island. That would have been nice. I don't know if it would have been as productive,
Right.
but so I immediately went to go work for a firm in Tampa. And then a couple years into that, they were going to open a branch office in Pensacola. And I thought, well, hey, I know the area and I know the attorneys. My father's an attorney, so I knew the legal community up there. And so my boss allowed me to go up and open the branch office, and did that for about a year and a half. And we parted ways, and I opened my own practice in the same office as my dad. And then a couple years later, we joined up. And so in 2004, we formed Mays Law Firm. Primarily insurance bad faith is what I did from that point forward. Prior to that, I was doing a lot of personal injury and premises liability. But insurance bad faith, a very nuanced area of law, and a lot of traps that that both the common average person who doesn't have a legal education can fall into, but even more so attorneys would fall into these traps that could potentially destroy a bad faith claim or infringe upon their client's rights, really, because it's a cause of action.
Yeah.
And so then, about 20 years into it, 21 years into it, I thought, I'm done litigating cases. That's all I've done my entire career. It was exhausting.
Yeah.
And I was ready to do something else. And so I thought I'd step away from the law. But my father always said, John, this was like year one of practicing law. He said, John, practicing law is a lot like dancing with a gorilla. You're not the one to decide when to sit down. And it was within 2 years.
I've never heard that before. That's a great one.
It is. And it is like dancing with a gorilla. That gorilla grabbed me back and said, you deserve to be back in here.
Yeah.
And I missed it. And interestingly, I missed it so much that I was broadcasting high school sports. I had started a sports broadcasting company, just local high school sports. We were having a blast, but there was a murder trial in the summer of 23 that it was the murder of an old high school football star. He was up at Kennesaw State and came back down, and it was just a mistaken identity, and they shot the wrong person. It was somewhat gang related, but he wasn't involved in gangs. They just got the wrong guy. But I was intrigued by that, and I sat through the whole trial, and I thought, yeah, let me get into some criminal law. So I went to the state attorney's office, and I realized very quickly that that's not for me.
Yeah.
Um, and so I then started looking, and then in early 24, I landed here at Legal Services in North Florida. I was lucky enough to have an opportunity, and I just love it here.
Yeah.
Because, Legal Services in North Florida, for those who don't know, we are an LSC, Legal Services Corporation, funded primarily law firm, 100% grant funded and donation funded. And what that does is that allows us to provide free legal aid to the low income and vulnerable in our areas and those that would qualify under grants. And so it's really an opportunity to provide legal advice and legal representation to people who normally wouldn't get it. And
Yep.
to me, that's a wonderful thing, and I couldn't be happier here.
Well, you and I have met because of your involvement with legal aid services, and because as you know, and I'm sure the audience knows, our law firm represents landlords, primarily apartments, property management companies, investors, and so many times tenants will go and they'll hire you guys, and so we'll see you in those cases, and so you and I've had the opportunity to handle cases together on the opposing sides of the V. And through that experience with each other, I thought, man, John would be a great person to have on the show. So, and I'm so thrilled that you're here. So I want to share, really just experiences between both of us for the audience, because, we see these cases obviously from the different sides of the issue, and we're representing different interests. But, there's some commonalities obviously between what you do, what I do, and that is we're trying to resolve cases many times. We're trying to put our clients in a position to where they can resolve the problem, they can move on, and put that thing to bed, and get on with their lives. Sometimes that means, sometimes it means the tenant staying in place. Sometimes it does. Sometimes it means it moving out, or whatever the case may be. Or sometimes it means, hey, we just need the judge to decide this. So there's different ways those things are handled. So, but I want to kind of delve into first is giving folks just really an appreciation for the complexities of landlord-tenant law and why it's so important, whether you're a tenant or a landlord, to have the right legal counsel on your side. So kind of jump into that for us, John, and share your experience on that.
Sure, absolutely. So I was hired here as a disaster coordination attorney, and that essentially means that handle disaster related situations, and that could run, it's basically every area of civil law, but at hyperspeed. So one area obviously is landlord tenant, and one of the things, luckily we have been, knock on wood here, lucky enough to have not had a storm in our area that has been devastating to the community for quite some time. So I'm taking the opportunity to learn about landlord tenant, because this is a new area of law for me, relatively considering my legal experience. So the most interesting thing to me to begin with in learning this area of law is how nuanced it is. And I was talking about how nuanced bad faith insurance law is. I think landlord-tenant law may be even more nuanced in just the little things that could either make or break you, and little procedural things that if you're not following can really negatively impact your position, your defenses, your cause of action. And so the entire time since I started working here, I've been doing landlord tenant, and I learn every week. I learn something new that I didn't know. And when I say it's nuanced, I'm talking there's state laws that govern it. There's administrative codes that you need to be aware of that govern. There's HUD regulations that govern. Some properties have, actually the IRS is involved in overseeing compliance, which doesn't seem to make much sense and probably isn't the most efficient way, but those are the low income housing tax credit
Right.
programs.
Right.
Um, and depending on the funding, even sometimes if a homeowner got a FA loan or a VA loan and then are renting it out, there may be additional obligations on that landlord that may not exist under a traditional mortgage.
Right.
And these are things that, if you're not aware of these little nuances in the law, you can get into trouble real quick. And from a tenant side, it's, we're looking for where the landlord made mistakes if we're going to be defending this case,
Yep. Yep.
And from your side, I would imagine, obviously, you're looking at the things that the tenant did wrong. And the tenant may think, oh no, under the statute, I can do this, but they're not aware of that regulation, which, takes precedent over whatever it may be.
Yep.
So, and I know we'll talk about this, but I can't stress enough to those at home on both sides of landlord tenant how important it is to have attorneys representing their interests.
Yep. Well, it's interesting because landlord-tenant law is one of those areas where there's a perception that it's a DIY kind of a case. Like everybody can just do it themselves. And, and really, if you look at the docket on the various clerk of court websites throughout the state of Florida, I mean, I would say the vast majority of them are handled pro se without attorneys. I mean, and we're talking about even, companies or property management companies, they think they can do it themselves. And so it's just fascinating to me. But, having done this area of law now for, since 2006, so 19 years, I've been specializing in this area of law, been an attorney for 21 years. That when you mentioned earlier about the 20-year mark of your career and how you shifted, I'm like, well, I'm right there where John was, but I'm still neck deep in it, John. So I'm not going anywhere.
Good.
But you look at, they just they think they can do it themselves. And so when I look at these cases, and ultimately when someone comes to us and they ask for help, and even this could be a long-standing client, a client that we deal with every month, we're looking at their cases or their situations. And I can tell you that we're always, even for long-term clients, we're tweaking stuff. We're saying, look, it would be better if you did it this way. Stay within these rails or take these additional steps, because we want to make sure that they avoid unnecessary defenses, unnecessary litigation, wasting of time, causing confusion and delay and conflicts. So we're trying to avoid all those things. So we're always doing that. But when you have someone who's new to us and they have this, you call it a one-off eviction, if you want to call it that, I can't really think of a time when we didn't have to basically start over for that client, because they just messed up so many different things. And I tell them, look, I can understand why you don't know all these things, because it is actually pretty involved. It's pretty complicated. And so from the tenant side of that, I'm sure it's the exact same way. Like they don't know just how procedural in nature these things are.
Absolutely. And you make a great point. One thing that I left out as statutes and regulation, case law.
Yes.
Case law interpreting these things is really important. And so, I could see, and we do the same thing here, is you get an opinion down from the county court, or maybe even if we're lucky enough to get a district court opinion on a certain subject. You got to read that, be aware of it, and then if you've got to make shifts in the way that you're approaching based on that case law, you got to do it. And because you're representing the best interest of your client. And what may be going on in Jacksonville, and the way the county court judges are interpreting particular statutes may not be the way they're interpreted here in Escambia or Santa Rosa County.
Right.
So knowing those little nuances, even within that, is critical. And there's no way a layperson, and I don't mean to offend anybody by the phrase Google lawyer, but I'm a web doctor. If I got a condition, I go look it up, and I'd rather go to a real doctor, because that doesn't help me. I get some answers, but that's not from the profession. And so it's really the same kind of thing here in landlord-tenant thing, and litigation. And I know we're going to talk about some mistakes that I wrote down, and you kind of touched on them. But One of them is just not, that I didn't write down, is not being aware of these rulings or laws or statutes or how they interplay with each other. And
Yes.
and you really need that legal background to sift through those things.
Well, even not just the legal background, but legal specialty. I mean, I know a lot of lawyers who they refer all their landlord tenant stuff to us because, yes, they're attorneys and they're great attorneys and they specialize in their areas, but they know really nothing about landlord tenant law. Or if they do know something, not enough to feel comfortable with it actually handling the case. So that should tell landlords and tenants both to say, look, even if here's an attorney that's not even willing to jump into this case, that should tell you something about pro se litigation, right?
Absolutely. And to use the doctor analogy again, you're not going to go into an orthopedic surgeon for heart surgery. They're a great orthopedic surgeon, like a great trial lawyer in personal injury. But if you don't know the heart and you don't know landlord tenant, you're going to get into trouble.
Yep.
And so the law has really become specialized, very similar to medicine.
Yes.
And that's, really important for people to understand that.
It is. So when I give seminars, of course, I'm explaining a lot of the issues that they deal with, whether it's, daily sort of things that they would see or even uncommon things, to just expose them to these issues so that when they encounter them, they can at least be aware, oh, I remember this, or hey, this is in the material that Tim gave us and I need to probably call him about this. But when I look at it, I have a library of cases that I have created over the years. And, when you look at Florida in particular, there's 67 counties, and within 67 counties, you have multiple judges for the most part. So we have hundreds of judges in Florida that are looking at these cases probably every day and ruling on issues. And then also we have the District Court of Appeals from those counties. So there's just hundreds and hundreds of cases in Florida on landlord tenant. And here's the thing about it, as a lot of people probably know, they don't always say the same thing. So in certain districts, you may say, well, this county or this district tends to go this way on this issue. And then on this area of the state, it's kind of goes the other way. And unless you have a Florida Supreme Court decision that has decided those issues, you've got to be aware of where you are and how these judges rule. Is that how you guys look at it?
Oh, absolutely. 100%. And it doesn't mean that we're not going to, make those arguments. But when I sit down with my client, I explain, hey, there's a conflict in the way these are viewed in Florida courts. And, we've talked in the past, Tim, about, our job is to outline the risks and benefits based on the factual scenario that we're presented and the law, applicable law. And one of those risks that I always go over is, look, if there's a conflicting situation in the law, you've got a conflict here. There's no definite answer here in Escambia County. Palm Beach rules one way, Duval County rules another way. Escambia has loosely addressed it, but we don't have a clear answer on this exact issue. So it could go either way.
Yeah.
And, to me, this is where the communication among the parties is key, is critical. Once you do that risk and benefit analysis, being able to pick up the telephone and call somebody on the other side like you and work through these issues is invaluable. For me as an attorney on the tenant side, I would much rather be on the other side, have on the other side somebody like you who knows the law inside and out, who will pick up the phone and talk to me, who will be frank. Hey, John, you got this issue right here.
Yeah.
And I say, yeah, I know. We do have this. And you say, oh, I know. I'm aware of that. And many times where that leaves us is this is going to go to the court or the finder of fact who's going to make the decision. And I can tell you that I can't remember ever trying a case in any type of law, whether it's criminal or landlord tenant or insurance bad faith or personal injury, where we tried the case and we got everything we wanted.
Yeah.
It doesn't happen.
Right.
So when people realize that, yeah, it might happen.
Yeah.
lightning does strike.
Yep.
But by and large, you're not going to get everything you want. And so when people realize then that helps the communication, which helps to get to a resolution, which helps landlords save money. It helps the stress and anxiety for the tenants getting resolution to an issue. And it helps the judicial resources. It doesn't clog up our courts. And if we have clogged up courts, then the judges feel the stress and they want to move their docket. And then that pressures them. And sometimes they might miss something that they normally wouldn't. And so then it just becomes this big snowball thing.
Yeah. Well, there's a human aspect to all this. And even the judges, you know, there's a statute we have, and there are certain procedural aspects that must be followed. But here's the thing, and I know you guys know this as well, but I practice throughout the state of Florida. And when I deal with a judge who's, say, for an example, dealing with the tenants posting rent into the court registry to be able to go to a final hearing, you know, the judges look at that quite differently. Even if they require the tenant to post that rent, some judges will, first of all, they won't hold a hearing. They'll just make a finding of fact on their own, on the pleadings. They'll order the tenant to post rent. Maybe it's a week later. Maybe it's 2 weeks later. Maybe they'll hold a hearing. And so they treat these things differently. And, you know, as a landlord's attorney, you've got to adjust, you know, how you handle your case, how you advise your client, what's in their best interest according to how these judges rule. And here's the thing. A lot of clients say, well, that they're not allowed to do that. And I say, well, that may be true. And they could be right. Maybe they shouldn't do that. But here's the thing. Your remedy now is to appeal them. So now you've got to go through the appellate process. Do you want to go through the appellate process too and pay for those expenses and those fees to try to correct the judge? And they could, so, you know, sometimes that happens. But most of the time, landlords are like, they're not out on a mission. They just want their property back in the most timely manner they possibly can get it. And so it's like, well, there are ways of doing that without having to go through, you know, costly and timely appeals. And typically, as you well know, John, that means, well, let's resolve this. How do we resolve this now to bring it to resolution?
Yeah, absolutely. And, you know, you can't get there without communication. You know, if I get somebody on the other side that is representing themselves and they think they understand the law, they're not going to be as willing to review case law that I have supporting my position and reanalyze. You know, it's funny you say that they can't do that. And it's something my dad taught me early on. You know, people say, oh, you can't sue me for doing the right thing. Hey, anybody can sue you for anything.
Yep.
Are they going to be right? Maybe not. Are they going to end up getting fees imposed against them because it's a frivolous claim? Maybe so. But anybody can file a lawsuit. And guess what? You're now defending it.
Yep.
And now you're having to do all these things that you could have avoided by doing, you know, A, B, and C that are real simple beforehand and extinguishing any possibility.
Yeah. Well, as you say, because
that falls into mistakes, you know.
Yes. Absolutely. So, well, the more mistakes you make, the worse your case is. As they say, bad facts make bad law. Yeah. And so that's, you know, we're looking at that from that standpoint. Like, look, you don't want to really go to the judge on bad facts. And when I look at a case, again, especially with my longstanding clients where I'm trying to help them out on a regular basis, is that, first of all, you don't want a reputation with that judge of trying to do things the wrong way. Okay. Now, mistakes are made. Sure, the judges understand that we're human. Maybe you shouldn't have done something, but you should be acting in good faith. Your operations should reflect that. And so when we look at this, we say, look, we think that this is a bad scenario for you. Here's why. We can help you recalibrate your case, do it the right way. And at the end of the day, if we do have to pursue an eviction, it's going to be right. It's going to look right. And you're going to maintain your reputation in front of that judge.
No doubt about it. I know that when I have a case that you're on the other side, if it's a long-standing client, that I'll review the file and I know everything's going to be done right. And then I can have that. I really do. Yeah. And But we've had situations too where you've come in and had to kind of undo things and
Yeah.
and start over, and the fact that you're willing and able to do that, I think, is helpful to the entire community because, we don't need to be pushing bad cases, trying to make bad law.
Yeah.
If everybody's on the same page as to what's expected, landlord, tenant, then it's a lot easier to work through a lot of these issues.
Yeah. Well, we've talked about this before, John, where the truth of the matter is if you had someone who knew what they were looking at and were able to look at every eviction case filed in a particular county, the truth is most of those cases, and I'm guessing because I don't have like some scientific data except just my own experience, I would say probably 90% of those cases could be mediated effectively because first of all, you're seeing what the landlord did wrong. You're seeing what the tenant did wrong. And when they understand where their cases are, you could explain probably in 5 minutes. I feel like I could explain in 5 minutes. Here's why you probably should think about selling today to be done with this. And that's unfortunately, it's not something that it's routine because, as you know, John, the statute does limit the court's ability to set mediations and trial in the event they have the tenants haven't complied with their part of 83.60 subsection 2. So there's those things, but just as a philosophical matter, a lot of these cases really could be resolved.
They could be, and I would love to see mediations pushed earlier in the process or just pushed at all. I would love to see a mediation program set up in the landlord-tenant realm here in Escambia and Santa Rosa. I think that there's a lot of value there, and there's value to your side, there's value to the tenant side, there's value to the courts, and just exactly what you said. 90% of these things can be resolved and should be, and that goes to. I wrote down a couple mistakes. One of them for landlords that I see is doing it themselves. And whether it's the landlord or their property management company. Oh, we can file this lawsuit. Well, yeah, but there's only so far you can go. And if there's an answer file, guess what? You're going to need a lawyer anyways. And then they just continue on.
Yeah.
And they don't realize that they need that lawyer.
Well, what's worse than that, John, is if they do realize it and they still go forward.
Yeah. I think that I don't know. I can't project on what they know or what they don't know, but most property management companies should know the limitations of what they can do in terms of filing an eviction. I think that should be, hornbook type stuff.
Yeah.
So, it is worse if they know it's wrong and they still do it. Another issue with doing it themselves is it's personal then. We as attorneys were taught very early on, don't represent yourself or a family member. It becomes way too personal in any action. And so that's why we hire lawyers if we have a situation arise to represent our interests. And the same thing in a landlord-tenant. A landlord or a tenant is going to take things so personal. And, they hear that you're not maintaining the property as you should. And a tenant hears I'm sloppy and here's something completely different. They're taking it personal. They're not able to separate those issues. And that's the same thing on the landlord side. Get out of my house. I'm digging my heels in. You messed up. There's no room. I am right. And there's no room for negotiation.
Yeah.
And, like we discussed earlier, you try a case, very rarely do you get 100% of what you want. Why not resolve that and come to that median ground much earlier, and then everybody can move on?
Well, and that's the thing about it. And sometimes, when I talk to my clients about settlement, they object on a principle. That's the word that's used. I don't want to settle on principle, meaning the landlord's in the right, the tenant's in the wrong. Okay. And look, that very well could be the case. The tenant didn't pay rent. There wasn't really a real hardship going on. It wasn't something that was sudden, abrupt in their life. It was really just a matter of they didn't manage their money properly and they don't have money to pay rent. That happens. Okay. So so the landlords feel like they're not, they're in the right. So why should they settle? And I tell them, look, this really has nothing to do with that. Do you want the property back in a timely manner with the least cost involved? This is a business decision. You're in the business of renting property out. I'm going to tell you what I think is going to get you to that result the fastest, most effective, least costly way I can. And it's settlement, but it's still a business. You still got to make good decisions. So,
yeah, principle. That's one when a client comes in, and I go back to my prior years in private practice, and where we had to bring the clients in to generate the income to support the law firm. And if somebody came in and walked in with a case and said, I don't care that I broke my leg and I have rods in it because of this car accident, this thing's personal to me. And this is a matter of principle because that person shouldn't have been doing X, Y, Z. I run away.
yeah.
Because that's not the right reason to be bringing a lawsuit. It is to get back to where you were prior to whatever event it was.
Yeah.
Not in a better position, not in a worse position. Try and get back to where you were.
Yeah.
And the same thing applies in a landlord-tenant. Get back to where you were. Okay, the landlord wants the property back, or the tenant wants the heat fixed.
Yeah.
Whatever it is. And these things can be, maybe the tenant was wrong in doing one thing, but the landlord was also wrong in doing something. And it's how do these things work together? And if you're representing yourself, you're taking it personal, it's principle, and you're not able to work through those and separate that and work through those issues.
Right. Yeah, exactly. Well, and the principle, when we talk about principles, first of all, the courts are not adjudicators of like some moral or ethical right and wrong. I mean, they're not, okay?
Right.
They are looking at facts, they're looking at law, they're applying principles of equity and justice, these types of things within the framework of law. But there is a principle in business of making good business decisions. I mean, and the tenant is sort of the same way. You got to make a good decision based on your circumstances. What is the result that best serves my interest here? And as attorneys, we know that many times they can be settled. Sometimes they can't be settled. Fine. And as you know, John, some cases do proceed in litigation up to a point. Maybe on the night before a hearing or a trial, say, okay, look, here, let's resolve this. And I'll say this because it just jumped in my mind because you said it earlier. Even on your best day in court, there's risk. You may not get everything you want to get. So I have in my career tried 59 jury trials and even more than that in judge trials. And I can tell you that, and it's really hard to articulate this, but the slightest thing in a trial can shift the fact finder's mind. One statement, one attitude, one demeanor can change how the jury or the judge looks at your case. And I've had many cases where I thought, man, we had strong facts, we had the law on our side, man, we're going to win this, we're going to be solid. And during the trial, something happened, and I could tell it shifted the tone of the case. And I learned early on that there is such a human element, an emotional element that inside the courtroom, even with judges, there's that aspect of these cases. And so I say to my clients, look, I don't care what we have. There's always risk because things can happen in the trial that you didn't anticipate, you didn't know was going to happen, or even the witness that you thought was your star witness says, oh, I think so, instead of I know so, and all of a sudden now we've got some doubt or something like that going on.
Yeah, exactly. And then the other side will pick up on that and say, you think so. So if you think so, then you think not so too.
Yeah, right.
It's not a definite. And it's so interesting that you're saying that because it really is. We have rules that are given to the jury, instructions that are given to the jury. Hey, you can't let sympathy sway your decision.
Yeah.
Well, guess what? We are human.
Yeah.
They are human. Judges are human. And whether they know it or not, that sympathy does come into play. And it could be one word that changes the whole trial that's said in front of the jury.
Yep.
It could be one objection. It could be a response to an objection. It could be
Yeah.
anything. And so
Right.
the risks of going to trial are far greater than anything that you could get out of resolution where you're certainty to what you're getting.
Yeah. It's
And to me,
fascinating. It really is fascinating, John, if you think about it. Just that whole dynamic. I mean, trials themselves just sort of have a life of their own. It's just amazing.
it is. It really is. I want to, if I could, just talk about a couple of things that I see. Um, I talked a little bit about, landlords doing it themselves. Another mistake I see on the landlord side is notice issues.
Yes.
There's all sorts of problems that they can step into if they're trying to do it themselves. What's the proper days they've got to give? What's the proper amount? Am I adding a late fee when I shouldn't be because the lease doesn't say it's considered rent? And all these things are landmines for an unrepresented landlord. And on the other side, on the tenant side, the biggest mistakes I see for the tenants, number one is calling an attorney too late in the process.
Yep.
These are they're called summary procedure type cases here in Florida, which I call a rocket docket. I mean, it is fast.
Yep.
It's much faster. And the intent is to get the property back to the landlord, and that's understood, or get a resolution so that the parties know where they are. And if the landlord entitled to get the property back, they do. If the tenant's entitled to stay at the home, they're entitled to do that. So calling too late on the tenant side. The other big one is not saving the money. The tenant that's representing themselves, who's withholding rent, then all of a sudden starts spending this extra income
Yep.
that they see. And it's not extra income, tenants. That is rent. And the court will make you deposit it with the court if you want to raise any defense in an eviction.
Yep.
The court will decide what that amount is. The court may or may not take into consideration conditions of the property when making that decision. The point being, and what I tell my tenants is, whatever that full rent is that you owe, save it, put it in another account, act like you don't have it. But the reality is that for my clients, that's a hard thing for them to do because sometimes they're deciding between rent and food. And that's, the type of the community members that I see here at Legal Services.
Yeah.
They're one unexpected bill away from being homeless.
Yeah.
It's not that they're bad people or that they mean bad. It's they miss a payment and then they get behind and then it just cycles out of control.
Yeah.
Well, there's resources out there that are available for those situations. And if you open the dialogue with the landlord side and say, listen, here's what I faced. I'm getting this together. Will you work with me? And the landlord sees a good tenant, that missed a payment or two, is behind, but sees that they're trying to get the resources to help. I think that there's room for talking there,
Yeah. Well, most of my clients are willing to enter into those negotiations even before filing an eviction. Obviously, for tenants who are well behaved, I'm going to say that word like their children has not would
Right,
my intent,
no,
but they're following the rules. They're otherwise they're not a problem, but they're having some financial difficulties. I mean, the vast majority of my clients, I mean, I can say all of them really are they try to work with them to some extent, and so. Having a good relationship with your landlord is important because it does at least enable the tenant to have a conversation about that. And a lot of times what will happen is our clients will contact us and say, hey, here's our situation. We really need an agreement put in place. And so I prepare payment plan agreements all the time for that situation. And if nothing else, John, here's what it does. The tenant knows that, okay, here's my deadline, here's my schedule. And even if realistically they can't meet it, that's the timeline. They know the timeline. There's a reason, there's an expectation there. And then the tenant or the landlord still has to go through the eviction. I mean, if they don't comply with the agreement, there's still an eviction process, which, as you know, John, typically takes at least 2-3 weeks, even if it's non-contested.
Yeah. Yeah, it does. And then, the certainty of that time frame is key too. Because if the tenant realizes I can't meet these financial obligations, my deadline is the end of April. Well, it's April 14th. I got to try and find somewhere else that is more affordable for myself.
Yeah.
It's something where I can make those payments on a regular.
Yeah.
Where one, I got to get a new tire isn't going to put me in a situation where I can't pay rent again.
Yeah.
And it's just, the problem comes when you have a tenant who tries to take advantage of that. And, I have to sit down and say, look, you don't get to live rent free. That's not what this is.
Yeah.
Now, I know you have, no heat and, a roof that leaks and you have mold that's grown because of the water intrusion and you can stick your finger through the wall. But, you don't get to live for free. You have a legal right to withhold that rent so that entices the landlord to make these repairs. That's the whole purpose of withholding rent, is to get it's a remedial measure. Hey, wake up, landlord, you got to make these repairs.
Yeah.
So, I just, I think the expectations on either side are catered by representation.
Yes. Yep. Well, I mean, I don't know if it's, what you guys do is great for the community because people who wouldn't ordinarily be able to have access to an attorney can do that and learn of what their rights are and what their responsibilities are. But again, it's a timing thing because if they do it too late, sometimes it's hard to unravel that yarn or to ravel it back up if you want to look at it from that perspective. But, so it's just one of those things where unfortunately, again, I think, and I don't know who's created this perception. Maybe it's a natural perception because landlord-tenant relationships have historically, sometimes even just verbal agreements. One landlord owns 2 houses, and he rents out one to a tenant. There's not a lot of formality to it, and there's not a lot of necessary professionalism in that whole relationship. But that doesn't remove the fact that there's still all of these obligations and hurdles and procedures in law, and unfortunately, the ones who don't see the need to contact the attorney are the ones typically that suffer the most.
True that. And that's the important, it's a great point. These verbal agreements, those are huge traps. They're traps for landlords and they're traps for tenants. Get a lease in writing so that, the statutory obligation. Well, the tenant and landlord don't really, that's what the lawyers do. But many times those are subsumed within the lease themselves.
Yeah.
And so read that lease. Those responsibilities of the tenant are right in there. So, a verbal lease leaves so much open to interpretation that is dangerous for both sides.
It is. Even some leases that are not worded well could create that kind of problem. I mean, really, and I've said, and a lot of the articles I write say this repeatedly, is to say, get a landlord-tenant attorney to draft your lease, and not just some generic landlord-tenant, a residential who specializes in that area, because there's just too many issues that need to be addressed in that relationship.
Absolutely. And it's an important distinction, residential, because the commercial side is a whole different animal.
Yep.
And there's other situations and issues that arise there that don't necessarily arise in residential. You need somebody who focuses on that residential side.
Yep.
It's critical.
It is. Well, I think we're going to try to wrap this up here, John. Look, I really, really appreciate you coming on today. I know the audience who's listening really gleaned some great things from you and from your experience. Legal aid, what you guys do, even though we're on the opposite sides of these things, I appreciate what you guys do. And if there's any perception out there that because it's a pro bono law firm that you guys aren't quality, that's a complete misconception, because you guys do great work. You know what you're doing, and it's a great outfit. And so I appreciate that, John.
Thank you for the kind words. I couldn't be happier here at Legal Services in North Florida, and what we're able to do for the 16 counties from here over to Jefferson, all the way over to Tallahassee, just east of Tallahassee, is an honor to be able to do that and be entrusted with that responsibility. And so to hear those kind words, I appreciate it, Tim. I look forward to handling cases with you on the other side in the future.
Yeah.
And I hope we can do this again. I think that we can talk through a lot of issues that'll be helpful to those at home.
Yeah, absolutely. Well, there's a lot of room for public knowledge and education on this topic. There probably the sky's the limit on what could be done in this realm. So I appreciate you saying that. So any final words, John, before we let the audience go today?
I hope everybody has a great rest of their day, great rest of the week, whenever they're listening to it, whether it's in April or May or June or next year.
That's right.
It's still here. And again, Tim, I appreciate the opportunity. I really do. So thank you.
You're welcome, John. All right, everybody. That's going to be it for today's show. Thanks for listening. I'm going to put notes as to how you can get in contact with John and Legal Services of Northwest Florida, right, John?
North Florida.
North Florida.
Yes.
Put that in the notes. Of course, I'll put information about who I am and how you can get in contact with us. So thanks for listening, everybody, and we'll see you on the next show. Thanks so much.